I'm Mark Weiss. Welcome to Wisdom Applied. I'd like to talk to you today about physician employment agreements and subcontracts, specifically those that pay the physician on a production basis. In other words, pay based on time worked or shift worked or on units generated. Now, those agreements have a provision that deals with the amount of work that the employee or subcontractor is promised. Either they promise a set amount of work or a minimum amount of work, perhaps expressed as a guarantee, or they state that the employer doesn't make any promise at all as to the amount of work or the amount of scheduling that the employee will receive. Or lastly, there's a provision that gives the employee or subcontractor the promise of an equitable amount of work. Now, from the employee perspective, a minimum amount or a guarantee is preferable. The employee therefore knows the minimum that they're going to be earning and has the right then to demand, pursuant to the contract, either that they are permitted to work that amount or that they are permitted to be paid the amount that they would have earned had they been scheduled. From the employer's standpoint, the provision that doesn't promise any specific amount of work is generally the more favorable provision, and that's because not only does this allow for flexible scheduling of employees and subcontractors as work goes up, scheduling goes up, and vice versa, but it also, importantly, permits the employer or subcontractor to use that provision as a sword, in essence, to enforce behavior and compliance with other contract provisions, as well as with performance outside the scope of the contract. In other words, the employee or subcontractor knows or can be made to know that if they do X, Y, and Z, they won't be scheduled. The third type of provision that I mentioned, the fair or equitable amount of scheduling, is perhaps the most dangerous, both for the employee and for the group. And that's because no one knows what fair or equitable means. Is this fair and equitable in relation to how other contractors, subcontractors are being assigned work? Is it fair compared to other employees of the same classification? Is it fair and equitable in comparison to the way that the employee has been scheduled before? That type of provision usually creates problems. One area in which it is more prevalent in terms of generating problems is upon notice of termination. Let's say that the agreement allows the subcontractor to give the 30, 60, 90 days notice of termination. The employee gives that notice, and then subsequently, in other words, after the employment or subcontract term, looks back and says, well, you didn't schedule me to the same amount of work that I used to get, or you didn't schedule me like you did the other employees. Now, that may have been because the workload went down. It may have been because the employer, in essence, discriminated against the employee or subcontractor because he or she was no longer loyal. But it's far more likely to generate litigation. So fair and equitable may seem like wonderful terms, but those terms often bring trouble. What the group needs to do in determining how it is going to structure that provision, in other words, a guarantee, no promise at all, or fair and equitable, which I don't recommend under any circumstance, is to, of course, consider the job market and their relative bargaining strength, but it's also to make sure that the provisions of the employment agreement fit together with the group's overall strategy. In other words, the ability to take an employee off the schedule in order to achieve other goals, say goals in terms of the relationship between the group and the hospital. If this is a group that holds an exclusive contract, may be extremely important to the group, and therefore, in light of that overall strategy, it must have an employment or subcontract provision that permits for scheduling flexibility without having to pay the employee while he or she is off the schedule. So remember, these agreements are not standalones. They're not simply forms. They're not simply even complex employment agreements, complex subcontracts. They're complex documents that have to fit together with the group's other documents, the group's other relationships, and the group's overall strategy.